Good day, Crime Talk aficionados. We have a Luigi Mangione update. His attorneys are saying, hey, that's not a manifesto. Will that affect his fundraising? Lori Vallow thinks the prosecution is starting to play dirty. Would you remain calm if someone put a gun to your head like this person did? Neighbor disputes are the worst. I have another example. Man killed for throwing a sandwich at his friend. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we go into the weekend, you're going to have a little bit of extra time. What are you going to do with that little extra time? You're going to get curious. You're going to get curious about somebody. And what are you going to do? Well, you need to go to crimetalksearch.com so that you can do a background subscription search on them right there. And the beautiful thing is you get that report literally while you wait, and it's going to have all kinds of information, telephone numbers, email addresses, last known addresses, property that people own. Do they have a criminal history? Do they have judgments, liens? Are they married? Are they divorced? All those things that you want to know about those people that are curious. Maybe someone coming into your life. Maybe someone thinking about, I need to get them out of my life. Maybe it's the parents of the kids coming into your life. Maybe it's the kid coming into your daughter or your son's life. You never know. Go check them out. CrimeTalkSearch.com. You're going to be happy that you did. All right, first on the docket, Luigi Mangione. His attorneys are saying, forget about it. That's right. If you don't know, Luigi Mangione is charged with first-degree murder in furtherance of an act of terrorism, stalking, and a slew of other state and federal charges in both New York and Pennsylvania for allegedly gunning down United Healthcare CEO Brian Thompson, a married father of two, on a sidewalk when he was going to a meeting in Manhattan back in December of 2024. Well, now his attorneys say that the police and the prosecutors' use of the words manifesto to describe Mr. Mangione's writings found in his backpack during his arrest on December 9th, well, that's just simply incorrect. And I think the big issue is, will that affect his fundraising? The attorneys write, the use of the characterization of the defendant's alleged personal experience and writing is incorrect, improper, and without justification, has no probative value. That's right. His defense attorney in Pennsylvania said that, this Thomas Dickey guy. And he said the defendant believes that the characterization was done solely for the purpose to prejudice the defendant and put him in a negative light before the public, all in an effort to prejudice any potential jury pool. As I noted, Luigi Mangione allegedly shoots the CEO, Mr. Thompson, outside of his hotel. Now, the prosecutors believe that the writings were a message to the insurance industry, basically to scare people, and obviously it was found in his backpack when he was arrested. Now, Mangione apparently expressed his grievances with the healthcare industry, specifically naming the United Healthcare and the shareholder conference where Mr. Thompson was headed the morning that he was assassinated. Now, Mr. Dickey, the attorney for Mangione in Pennsylvania, is asking the court not to describe Mangione's alleged writings as a manifesto. He is also asking the court to suppress various other evidence, including what his attorney describes as a warrantless search of the suspect's backpack, statements made to the police during his arrest, as well as DNA evidence. Now, Mr. Mangione's attorneys argued that Mangione had been improperly detained and arrested at the McDonald's, so certain evidence collected during their arrest should not be submitted as evidence against their client. Now, this is interesting, ladies and gentlemen, because obviously if one court suppresses it, it's not binding on the other courts, but it's certainly persuasive that there was no alleged misconduct that violated the Fourth Amendment. So that's going to be the issue, right? Now, they see Mangione, that they believe is the guy that he is, that they're looking for. There's a warrant for his arrest. Police officers go, they believe that that is the guy, they go up to him and they arrest him. Now, certainly the police are going to be able to do kind of a cursory search of Mr. Mangione to make sure there are no weapons. They also believe that he was armed and dangerous, and they looked into the bag to see if there are any weapons. Sure enough, they found a weapon. I think it's going to be a tough road to hoe to get that suppressed. But hey, the way judges go these days, you never know. I mean, apparently they get everything suppressed. and everything you want from a judge these days, except in the cases where I'm in. I don't know what it is. I guess I only follow the law when it's my particular case. Anyway, now, obviously, Mr. Mangione has lots of supporters. They're characterizing him as an anti-capitalist crusader. He allegedly stopped at a New York City Starbucks for coffee minutes before the murder and was ultimately arrested while eating a hash brown at the McDonald's, where he was ultimately arrested. Now, Mangione is accused of meticulously planning the murder with the motive of igniting a public discussion about the healthcare industry, according to the Department of Justice. A discussion. You know, if you wanted to start a discussion, you could start a podcast, make a YouTube channel. I don't think you have to go to the extremes, if that's you, of allegedly shooting a healthcare CEO to start the discussion of the healthcare industry. Everybody knows insurance companies are evil. They suck. All right? And if we just got rid of insurance and everybody just self-insured and you paid as you went, I guarantee you the prices would be less. Next time you go to the doctor, ask the doctor, what's the cash price? And I bet it will be a third of what it would be if he has to take the time, bill it through insurance, have the insurance company reduce it. Okay, insurance companies are evil. The doctors know they're going to get it reduced, so they raise the price, so the insurance company raises the price. It's all just a big scam, ladies and gentlemen. Anyway, the New York prosecutors have also said that Mangione plotted to travel to New York, find Thompson, a Minnesota resident, in town for that shareholder meeting. Now, Mangione allegedly shot Thompson from behind with a 3D printed ghost gun and a suppressor. Now, the NYPD released a still image from surveillance video showing him pulling his face mask down and smiling while flirting with a clerk at a check-in at a hostel in Manhattan, where the police allege that Mr. Mangione stayed prior to his alleged killing of the CEO. Anyway, that video went viral and immediately attached a wave of supports online for the accused killer. Now, the suspect allegedly fled the scene after the murder, rode a bike to a bus station, and took a bus to Altoona, Pennsylvania, where he was ultimately arrested. Obviously, we'll give him the presumption of innocence. He's got a $700,000 defense fund, ladies and gentlemen. Like I said, will this affect his fundraising? If it's not a manifesto, it's just a list of bunch of grievances. I have had a bad day. I don't like the court. I don't like the clerk. I don't like opposing counsel. Is that a manifesto or a grievance? I don't know. When you track somebody down and you specifically list them, it kind of sounds like a hit list. Next on the docket, Luigi Vallow. She believes that the prosecutors are playing dirty. Why do you say she thinks they're playing dirty? Well, she is filing a motion objecting to a witness in the case, a now retired detective, a detective Daniel Coons of the Chandler Police Department. He was there at the scene that day, and the police have endorsed him as an expert witness just a mere couple of weeks before trial, and that's not going to give her sufficient time in which to get a new expert to rebut Daniel Coons. And now what Luigi Vallow is saying is, guess what? That guy, he's not an expert. Remember, ladies and gentlemen, what is an expert under 702? Somebody that has some specialized training and knowledge. That's right. So Luigi Vallow says Detective Coons' opinion as a detective would not be admissible at trial, generally so. So the state is now naming him as an expert to give him his opinion in front of the jury. Now, the CV, fancy word for resume, attesting to the expert's qualification has not been made available to the defense, nor has the defense interview occurred. For over a year, Detective Coon has been limited as a witness and not an expert. And noticing an expert allows the defense the opportunity to recruit a rebuttal expert. However, the absurdity of the timing of the disclosure now turned expert violates due process rights. This is not sufficient notice, enough time to locate an expert, request funding through the courts, and have the expert perform their own analysis and complete a report. And obviously be prepared and be able to show up and testify at trial. This is just downright dirty. Well, Ms. Vallow, I guess the court could strike the detective as an expert witness, but it seems as though the disclosure was made within the allotted time. So that wouldn't necessarily be a basis, but what would the remedy be? You could strike it, but that's an extreme remedy, if it's assuming it's all timely. Your remedy is a continuance to try and find an expert. But then you have to find an expert that you think is going to disagree with the prosecution's expert. And there you go. There you go. I don't think you want to waive speedy trial. Remember that, Ms. Val? That's why you're proceeding on your own, pro se. Oh, the tangled webs we weave when we try to play lawyer. Good luck, Lori. Good luck. You're going to need it. Next, could you remain this calm? So a well-known San Francisco street preacher didn't even flinch after a woman identifying as a transgender woman held a gun to his face after he said, God made men to be men. That's right. Kevin Kihara, a pastor from the Christian Forgiveness Ministries in San Francisco, was preaching the love of God near 4th and Market Street on Wednesday when a person believed to be a transgender woman threatened him with a gun. That's not very nice. So while standing beside a table with a microphone in his hand, sermonizing pastor delivered his blunt message. You need to try being less like somebody you are not and start to humble yourself and be somebody that God made you to be, the preacher said on the street corner. He didn't make a man to be a woman. He made the man to be a man, he exclaimed before adding, he didn't make the woman to be a man. He made the woman to be a woman. And this is the truth, is what the preacher said. Mr. Kahara then paused, looked into the distance and outside of his camera view before pointing at a person hurriedly walking into the frame. Calmly, the preacher asked the individual, who is dressed in a bobbed white-gray wig, denim overalls, and a black and white striped t-shirt, similarly patterned fingerless gloves, and heeled boots, if they were going to attack him. What, are you going to come and attack me now? The pastor said, as the emotionally charged person pulled a large black gun out of their purse, pointing it right at the preacher's face. I should, the alleged person carrying the gun replied as they held the gun just inches from the preacher's head. Now, the unnamed transgender woman, eventually lowered the deadly weapon and walked away in what appeared to be a fit of rage. Unfazed, the pastor then reacted to the threat. Hey man, it's up to you. If you want to pull that on me, God bless you, he said, as the gun-wielding individual can be heard yelling profanities at the preacher. Shut the F up, the wig-wearing individual screamed as they fled the scene. So you just threatened me with a gun. You just pulled a gun on my face, the preacher said nonchalantly. Man, Lord have mercy on you, the preacher continued. This means you don't even know who you are. I still love you, though. Even though you pulled a gun on me, I still love you. Bless you. I'm not sure I would be that calm if that would happen. I think I'd be a little more outraged. Perhaps I would pull a gun out and respond by saying, now I'm in fear of death or serious bodily injury, and you're going to get shot. Ladies and gentlemen, can't we all just get along? Be nice to one another. You don't have to agree with everything everybody does or says, but just be nice, right? Even if you don't like what they're saying, it doesn't give you a right to go pull an act of menacing on somebody and put them in fear like that. Nobody. Next, neighbor disputes are the worst. Let me give you another example. Audio has revealed the moments a New Jersey woman begged the 911 operator for help after a neighbor shot her and her husband, asking dispatchers to tell her kids she loved them if she bled to death. Now, Jill Kowalski and her husband, Tom, were left severely injured when their neighbor, John Adamo, suddenly opened fire on them outside of their New Jersey home on Tuesday afternoon after an apparent year-long feud between the neighbors. Please get the cops here, you can hear the woman say as she's bleeding to death. Now, the distressed wife was screaming into the audio, I can't leave my kids. If I do, please tell them that I love them. Now, just moments earlier, Jill had told the dispatcher she feared her husband was already dead outside their home. She said, quote, my husband, I'm thinking he's dead outside of my leg is killing me, the wife said. I'm in the leg left. My husband, I think, at least 3 rounds. Oh my God, there's blood everywhere, she added. When the dispatcher asked what type of gun the neighbor was firing, she said, an effing rifle. It looked like a rifle. Please hurry. I always got to love how those dispatchers remain so calm. I know they got to do their job, but it's like you can have a little bit of emotion, you know? They're on their way. What kind of weapon was it? It was a freaking rifle already. Anyway, police say that Adamo, who other neighbors described as a combative alcoholic who'd been in a feud with the neighbors, shot the husband as he was standing outside his home about 4:45 p.m. on Tuesday. Then he fired a gun at the couple's house and struck the wife as she was inside. After opening fire, Adamo retreated to his own home where he barricaded himself for at least 2 hours and then ultimately committed suicide. Once the cops got inside, well, they realized that he had taken his own life. The couple, meanwhile, was airlifted to a local hospital where they're both listed in critical but stable conditions. Neighbor disputes, man. I'm telling you, they're the worst. Your kid's ball rolled into my yard. Your dog walked on my yard. Your dog peed on my lawn. Your trees' branches are over my fence and leaves are falling into my yard. They get so out of hand, it's crazy. And usually somebody winds up going to jail or prison. Next, let it go or shoot the guy because he throws a sandwich at you. That's right. An Oregon man was sentenced to 34 years in prison this week after he pled guilty to gunning down a man who threw a sandwich at his car and then tried to kill the only witness to the murder. Please meet Jacob Fitzgerald. He pled guilty to manslaughter, attempted first-degree murder, first and second-degree assault, burglary, and robbery in 3 separate cases, beginning with the August 6, 2022 slaying of his friend Otis Abner. Now, Fitzgerald, his girlfriend at the time, and Abner were in a car when the two men began arguing. Fitzgerald stopped the car and ordered Abner to get out, then started to drive away. But when Abner threw a sandwich at him and hit his car, he stopped the car and fired multiple shots at his friend, ultimately killing him. He then drove away and burned the vehicle. Totally logical thing to do. No, it's not. Now, it wasn't clear exactly how Mr. Fitzgerald remained free for the next 18 months, but on February 11th, 2024, when he went to his now ex-girlfriend's home where she was living with her new boyfriend and fired multiple shots at the trailer that she was living in, striking her in the face and in the arm. And 2 days prior to that attack, the girlfriend, identified Ryan Smith, called the police and said that Fitzgerald was hunting her. Then on the 11th, Fitzgerald and his sister, Joanna, came to the trailer where she lived and forced the door open while Smith desperately called 911. Fitzgerald, once again, opened fire and again fled with his sister. Smith was taken to a hospital, survived her injuries, thank goodness. Fitzgerald and his sister were arrested more than a month after the incident. Now, Joanna Fitzgerald was charged with attempted murder, unlawful use of a weapon, menacing burglary, and is set to appear in court next week. The guilty plea includes an armed robbery that took place before Jacob Fitzgerald's March 18th, 2024 arrest, as well as a hit and run back in 2021. Like those good global dispositions, do you not? Yes. Next in the docket, this day in legal history. On March 14th, 1964, nightclub owner Jack Ruby was convicted of murder of Lee Harvey Oswald, who was presumably assassinated President John Kennedy on November 22nd, 1963. Now, Ruby was sentenced to death. The Texas Court of Criminal Appeals overturned Ruby's conviction in October of 1966 and ordered a new trial, citing improperly admitted testimony and improper venue in the original proceeding, but Ruby died before the second trial could be convicted. Now, what I want you to note, ladies and gentlemen, is that the crime took place on November 22nd, 1963. That's when Kennedy was shot. Okay? A death penalty case. He went to trial and was convicted on March 14th. November, December, January, February, March. 5 months, ladies and gentlemen, to do a death penalty case. Could you imagine doing that today? No, you probably couldn't, but it just shows you how much more simpler things were back then. The more evidence they have, the more difficult it gets sometimes. Next on this date, March 14th, 1902, the Senate ratifies the Hague Peace Conference Treaty, and that was unanimously ratifying the 1899 Hague Peace Conference Treaty, establishing the international legal standards for warfare. It was the start, for the rules of warfare. Then in 1903, the Hay-Haran Treaty ratification. That's right, the United States Senate ratified the Hay-Haran Treaty, granting rights to build the Panama Canal, a legal step in U.S. territorial and infrastructural expansion. And of course, we're going to get it back here soon. At least that's the way some people are thinking it will. I've been to Panama. I've been to the Panama Canal. They didn't particularly love Americans down there. I don't see them just giving it back, but that's just me. That's just me. Next, on this date in 1917, the first federal prosecution under the Espionage Act. That's right. Now, although The Act's dates vary. Early 1917, it saw initial enforcement action under the Espionage Act with the March 14th marking the notable escalation in sedition related to arrests during World War I. And on this day, 1950, the FBI launches the 10 Most Wanted Fugitive Program, and the FBI officially inaugurated its 10 Most Wanted Fugitive list for the significance of fighting crime. Get those dangerous criminals off the street, they said. And then on this date, March 14th, 1972, the United States Supreme Court hears Furman v. Georgia arguments. Oral arguments began on March 14th in the landmark case, which later led to a moratorium on the death penalty, reshaping the capital punishment laws after that little moratorium. We've all heard of dine and dash, right? You eat your food and you don't go out and you don't pay your bill. Well, how about a dance and dash? That's right. You get a lap dance and you don't pay. Guess what? It's a theft of property, ladies and gentlemen, theft of services. So please meet John Elberson. He allegedly unlawfully, which means without legal permission or justification, because the girl wasn't given it away for free, unlawfully obtained the property of another, to wit, a lap dance. Value? $160. That's right. The Florida cops charged that the lap dances were the property of Rain Ladies and Gents, a Clearwater, Florida gentlemen's club that promises visitors an atmosphere of opulence and grandeur, and where every corner of your venue radiates an air of exclusivity. Anyway, Mr. Elberson allegedly received several lap dances about 1:30 a.m., apparently just prior to closing time. When presented with the bill, so to speak, he notified the business that he didn't have the money to pay for it. He received $160 worth of services, according to the deputies, and they did notice that he had a certain level of indication of alcohol in his system. Anyway, Mr. Elberson was charged with misdemeanor theft, spent 12 hours in jail before a judge released him on his own personal recognizance bond. And the Apollo Beach resident was ordered to stay away from Rain's opulence and exclusivity. There's a couple people you don't mess around with, ladies and gentlemen. You always pay your attorney, you pay your CPA, and you don't try to dance and dash at your local gentleman's club. They will bring the hammer down on you. Anyway, Mr. Elberson, you are a dumb criminal of the day, not for going to the gentleman's club. No, that's okay. But for not paying for services rendered. All right, that's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. We'll see you next week. Have a wonderful weekend. And remember, the Constitution matters.